Assalamualaikum warahmatullahi wabarakatuh. Hi everyone, let me introduce myself. My name is Eka Safitri with NIM E1031-31051, Government Science Study Program, Faculty of Social and Political Science, Tanjung Pura University. Here I will explain one of the journals entitled Analytical Study of the Intervention of Legislative Body to the Constitutional Court in Indonesia compared to developing countries. To fulfill the assessment for the final semester examination for the Sistem Pemerintahan Indonesia, independence of judicial power is an ideal concept needed to realize a rule of law. But the independence of judicial power is vulnerable to intervention from various government institutions or political parties. The things that make judicial power vulnerable to intervention are the unclear concept of judicial power in the Constitution and the temporary limitation of the independence of judicial power over space and time in the existing political constellation. The independence of judicial power is very important in the rule of law system, especially in realizing ideal law enforcement. This independence is divided into two aspects, namely individual independence and institutional independence. Individual independence includes substantive independence and personal independence, while institutional independence means deciding a case impartially and based on fact and law. The independence of the Constitutional Court is very important to maintain accountability in the justice system and ensure decisions are fair and based on the law. However, the independence of the Constitutional Court does not mean absolute, because judges must be responsible for their decision and judicial power must be exercised in accordance with the values of justice, procedural and substantive material legal guidelines, as well as important parties involved in the case. The involvement of the DPR in the administrative process at the Constitutional Court is regulated in applicable laws and regulations, even though the DPR has the authority to nominate constitutional judges. The nomination process does not mean that the DPR has direct power in the process of dismissing judges. However, the involvement of the DPR in drafting the law governing the Constitutional Court could be a loophole that could lead to the risk of interference with the independence of judicial power, especially personal independence. Therefore, it is necessary to guarantee that the selection process for constitutional judges is carried out objectively and accountably. Furthermore, legislative intervention against the Constitutional Court or Supreme Court does exist and can be identified by looking at certain legislative intervention practices. The DPR has the authority to assess the implementation of the Constitution and create a constitution, so the relationship between the DPR and the Constitutional Court is quite strong. However, legislative intervention is not only limited to practice, but also needs to be explained in the data. In some countries, such as Indonesia and Russia, the legislative body has a role in appointing constitutional judges or Supreme Court judges. However, most developed countries do not involve the legislative body in the process of transferring judges, such as England and the United States, which appoint judges through procedures that do not involve the legislative body. The recruitment applied to judges have a significant role in maintaining the independence of the Constitutional Court. Strict and clear recruitment can limit legislative interference with the courts, whereas recruitment that are broad and potentially influenced by political interests can allow for political intervention. Indonesia strictly maintains the independence of the Constitutional Court in determining the Chief Justice of the Constitutional Court with a strict selection procedure led by the oldest constitutional judge. However, the possibility that the legislative body can regulate laws regarding in the Constitutional Court according to its interest still exists. The number of judges at the highest level in a country is very important. In some countries such as Indonesia, Canada, and Japan, the executive body has an important role in filling the number of judges, while the legislative body does not have the right to do this. Developed countries have difficulty impeaching members of the Constitution or Supreme Court. Except in Indonesia. In Indonesia, the DPR impeached one of the Constitutional Court judges, Professor Aswanto. It showed that there was legislative intervention in the impeachment of judges, in contrast to other countries such as the United States, England, and India, which have never impeached Supreme Court judges. India has regulation that allow the impeachment of judges.